Uh, Mr. Ostriker, in Professor Jay's remarks, his written remarks, and also his testimony, he lays out the principle that federal judges derive their legitimacy from the respect that they command as a result of their personal competence, impartiality, independence, and integrity. Do you agree with that statement?
I do.
And how about you, Professor Bruce?
Yes, I do.
And to maintain that respect that they command as a result of the perception of competence, impartiality, independence, and integrity, judges should make decisions according to the law, unclouded by personal bias or conflicts of interest. That's another statement that Professor Jay makes in his written testimony. Do you both agree with that as well, Professor Bruce and Mr. Ostriker?
I do.
Yes, I do.
And do you also agree that when the public perceives a lack of competence, impartiality, or bias in favor of one party against the other, then the integrity of the judicial branch is undermined?
Of course.
Yes, but that's a more subjective view, depending on your point of view, then.
Well, but judges should strive to avoid an appearance that they might be biased in favor of one party.
Absolutely.
And this is the reason why judges, federal judges, are bound by the Code of Conduct for United States judges. Excuse me, for United States judges, correct?
Yes.
Is to protect those ideals and to ensure that that they abide by those ideals. And but it's troubling that U.S. Supreme Court justices are not bound by by that code of conduct for United States judges. Do you have the same bad feeling about that I and Professor Jay have, Mr. Ostriker?
I think that it should apply across the board to all the judges.
You, Professor Bruce?
For what the opinion of a computer scientist is worth, yes, I do.
Well, tell me, is there any reason why there is some uniqueness of United States Supreme Court justices that would exempt them from some code of ethics or code of conduct? And you've already answered that question, so let me ask this. Professor Jay, is there any reason, is there any constitutional basis that would prevent Congress from imposing upon the U.S. Supreme Court justices a rule that they abide by the Code of Conduct for United States judges, or that they write a code of conduct for themselves and abide by it?
Steve Gillers and I are both of the opinion that the necessary and proper clause, coupled with the power to regulate the appellate jurisdiction of the Supreme Court, gives this body the power to insist on a code of conduct. I think for those of us who are originalists, I think it's useful to know that the original Congress was happy to identify how many judges there would have to be on the Supreme Court, when they would sit, where they would sit. It made them get on horseback and run around the country. And so against the backdrop of those early regulations, the idea that you would simply say, look, we want to make sure that our judiciary ascribes to, that as a condition of the appellate process, that our judges subscribe to basic ethical principles, strikes me as being within the zone. I'm not sure, there might be a counter, there may well be others who disagree, but I think that there is congressional power for that.
Thank you. Mr. Ostriker, do you agree with that?
Yeah, I absolutely do. I think that, unfortunately, I believe what we're seeing now is the Supreme Court promulgates its own rules. So that, I think, would be the explanation for why they don't have rules that are in line with the other justices.
Well, I'm sure that justices, unlike judges, want to be judges of their own cases. And I think that whenever you have a justice that is solely responsible for judging a issue of recusal, then it diminishes the respect that people have for the court's perception of abiding by the law and being unbiased, impartial, and all the rest. And with that, I will yield back. Thank you.
I thank the gentleman. We now go to the gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman. I'm pleased to be